Our final speaker is once you've decided you're going to do a project and you've been awarded a project and you've figured out how to deal with the safe harbor issues that Beth was mentioning, can you afford the solution? Can you afford the project? And our final speaker is Brad Gould, who's going to talk about the tax consequences of payments for environmental services program. Brad is a triple gator with our law firm. He has his undergraduate degree, his law degree, and his Master's of Business Administration from the University of Florida. He's a shareholder in the tax department, works in the Fort Pierce office with myself and Dana Applebaum. He is on the Board of Governors with FICPA and is the Vice Chair of the S Corporations Committee of the Tax Section of the ABA. Brad?
Thank you, Michael. We always like to say something funny as a joke. Since I'm a tax lawyer, I'm about to bore you. I was going to say I'm the only thing between you and the bar. 2 other people have done it. So since I really am, I'm going to start a timer at 15 minutes instead of the 20 I was allotted and be your all's new best friend, okay?
And we were being given the sign at the back that they weren't going to get tack all the time one that I was hoping for. So you may only have 10, so you better get at it.
So y'all really like me. Okay. So in the book, there's a set of materials that we have. I don't have any slides, so you don't have to look at boring tax stats and things up there. Just listen to my voice, I guess. So we've heard about a couple of different projects today. Noah Valenstein talked about some. Beth talked about some. You got federal payments, state payments. Dr. Trottel just talked about the St. Johns County Crop Alternative Program. And so all of these things are money coming to you. Well, guess what? The federal government likes to tax money coming to you. And unless you can find an exemption or a deferral, you're going to pay some tax, all right? And is there anybody here that does not know the difference between capital gains and ordinary income? Seriously. Skipping that. All right. So what the general rule is you get a payment for a conservation program. And like I said, unless there's a provision that applies, and in the context of water conservation, the 2 sections that apply for the most part are Section 118 or Section 126 of the Internal Revenue Code. If they don't apply, we look to things like like-kind exchanges if the transaction meets the requirements, or we look at things like an involuntary conversion. And in both of those cases, you can defer the income tax recognition until some later date, which is usually when you sell the property. So the first one I want to talk about is Section 118. And what it deals with is a contribution of capital to a corporation. So normally, if you're a shareholder in a company and you make a capital contribution to your corporation, it's generally not income to the corporation. Well, if you get a payment from the government, they're not your shareholder. I mean, unless you're GM or were GM, they're out of GM now, but they're not a shareholder. So how is that a contribution to capital? So Section 118, which came up in the from the Internal Revenue Code all the way back in the 50s, says if there's a non-shareholder contribution to capital to a corporation, and that's the big key, doesn't apply to sole proprietorships, doesn't apply to partnerships, limited liability companies, taxes, partnerships. You've got to be a C Corp or an S Corp. Then the income will be exempt. That's it. It's very simple, except the devil's in the details. So what is a contribution of capital to the taxpayer? There's good regulations in there, and all the regulations basically come down with if you have a contribution by a governmental unit, a civic group, that's there to induce the corporation to locate its business to a particular community or to enable the corporation to expand its operating facilities, it's excluded from income. If it's consideration for goods or services rendered or subsidies paid to limit production, it's not excluded. For example, the St. John's Crop Alternative Program sounded to me like you're getting some money not to grow crops. Well, that's probably going to be income then. But if you're getting some money to enhance your facilities, then we might fall within this exclusion. So great examples. There's a revenue ruling, 93-16. And what I really like about this is the IRS really went and did an excellent job of summarizing the law. Okay, so the distinction is this. 1943, before the statute came out, there's this case called Detroit Edison, okay, versus Commissioner. Everything is always versus Commissioner in tax world because they're suing the IRS. They want their money back. And in this case, the Supreme Court held that payments by customers, prospective customers, to an electric company to build and install the power, the utility provision, so that those people could ultimately get service was taxable. So you got all these, customers, potential customers from the electric company saying, hey, we're going to give you money so you build a power plant and run lines to our home. Well, why are they doing that? They're doing that to get service. And the Supreme Court said, well, you're a potential customer. Versus this Brown Shoe Company case from 1950, where the Supreme Court looked at a community, and this may sound familiar, where there were community incentives to locate or expand an existing business. All right, in this case, a shoe manufacturer. So some community groups said, we'll put up money, build or expand your factory in our location so we have jobs in the community, we don't have abandoned property. And they said, yeah, we might buy your shoes, but we're not doing this so we can buy your shoes. We're doing this for other reasons. So the Supreme Court said that's not taxable. That's excluded. And that's the basis for 118. So if you have a payment that's coming in to induce some sort of service for the person making the payment, 118 is going to tax it. And so if a water management district wants to pay a farmer to harvest and store water on the land, the key question is what's going to happen to the water? Are they basically storing the water to then clean it up and redistribute it out into the environment, and the state is getting the incentive of clean water or slowing down the flow of water? Well, then that payment is probably not for goods or services. But if it's a utility company that's getting the water and then is going to turn around and sell the water back to the organization that provided them the money and the infrastructure to store the water, well, that might not then be exempt under 118. Another example I'll give is in the materials, and it's actually out of this same Rev ruling, 9316, was an FAA program. So the FAA was paying airports to expand their facilities, to improve their facilities, make them safer, less noisy, handle bigger planes. Oh, and by the way, the FAA could require a government plane to land on the property and use the airport. And the IRS said, but they showed this was never really ever asked. So it wasn't done for the purpose of the FAA to be able to land their planes wherever they wanted, or the government to land their planes wherever they wanted. It really was a public safety thing. And so the weight of the evidence said excludable under 116. So the only other thing I'll mention briefly on 118, excludable under 118. The only other thing I'll mention is that there is a different set of rules if we're dealing with a water or sewer disposal utility. And if you have one or you're involved with one, 118's got a little bit more complication to it. Again, that's in the materials. And we're at 7 minutes and 45 seconds.
But in those situations, you're only talking about corporations that can take advantage of 118, and we're only talking about the amount of money that's being given for a capital improvement.
Exactly.
Okay.
Exactly. Only for the capital improvement. If it's for a service, like not to grow, or you get money for capital improvement to build some water storage facilities, and then you get paid rent to store the water, that rent payment's not what we're talking about. That's going to be subject to tax. All right? And basically, you're getting that rent payment because you're not growing crops or running cattle or whatever else you would have been doing on the property that would have been subject to tax anyway. Section 126. This one is an optional provision. And by optional, I mean, even if you qualify, you have to elect to take 126 treatment. And in 126, there are 8 specific federal or state cost-sharing subsidies that are excluded from income. A couple of examples: the Federal Water Pollution and Control Act. There's an Ag Conservation Program under the Soil Conservation and Domestic Allotment Act. So you've got these 8 enumerated programs, and then there's a catch-all that basically if the Secretary of Agriculture and the Secretary of Treasury agree that this is a water conservation and soil conservation program that's consistent with these purposes, then they'll okay it. But you actually have to get a ruling for it to be okay.
Which is very important for your presentation.
Very important because Florida has a ruling that any payment from the state of Florida's Agricultural Best Management Practices Program qualifies. And this was something that I think it was Commissioner Bronson.
Correct.
There was an early one in '93, and then Commissioner Bronson had it expanded. So basically, if there's a program that qualifies under the Agricultural Best Management Practices Program, it'll qualify under 126, assuming it fits all the other criteria, but it's gotten the green light. So what's the criteria? It's got to be a payment to construct a capital improvement. That's primarily for the purposes of conserving soil or water resources, protecting or restoring the environment, improving forests, or providing a habitat for wildlife, and does not substantially increase the annual income derived from the property as determined by the IRS. How they go through that's in the regulations. It's fractions and percentages. I'm not going to bore you with it right now, but if you're interested, it's in here. So an example of not having a capital improvement is a reference to the Graves versus Commissioner case. It was a tax court case from '87, where a farmer received payments to offset a reduction in their income by establishing a wildlife habitat. So farmer said, all right, I won't grow in here, and I'll let the deer and everything grow, live and prosper, and I won't farm that section of land, and the government paid money. Well, they're being paid not to farm. They're not being paid to construct a capital improvement on that section of land, so it is not excluded under 126. It's not a cost-sharing payment. All the cost-sharing payments we're talking about, those are the ones that we care about here, sharing the cost to develop a capital improvement to preserve soil and water. If you take a 126 exclusion, so you get money in, you say, I'm going to apply this under 126 and not pay tax on it, then the thing that you built, you don't get to take a depreciation deduction for. And if you sell it within 20 years, there is a recapture provision. Everybody here heard of Section 1245 depreciation recapture? You know, you sell a piece of property you've been depreciating, you have to recapture it. Same concept. So for the first 10 years, it's 100% recapture. And then it phases out over the next 10 years. So if you make a 126 election, you have to think about it. One, do I want this depreciation recapture issue? Because it's recaptured as ordinary income. And it might have been that if you sold it, you'd have a capital gain. So you really have to look at your long-term plan with whatever this capital improvement will be to see if it makes sense. And so,
But 126 is available to any taxpayer if you qualify, not
Any
just
taxpayer.
corporations.
not just corporations. So the last thing that I want to talk about in the final 3 minutes, like-kind exchanges. Okay, so if you get some money, you have a piece of property, you go into a transaction, doesn't qualify for 118, doesn't qualify for 126. It might qualify as a like-kind exchange depending upon what happened. So for example, if you receive money to not use your property anymore, and that receipt...
Well, take Dr. Shortell's example of the decision that people are only going to do silviculture for a number of years, like a
Right.
conservation easement saying, I'm not going to do anything else but silviculture.
You're a little bit ahead of me.
Yep.
But-
But I know I'm getting the hook from
You're
the back of
getting
the room.
Right. So if you have a transaction that qualifies, almost to the extent of qualifying as a sale of land, okay? But you still own it. Maybe it's a lifetime or a conservation easement of a particular duration. It could qualify for Section 1031 like-kind treatment. And like-kind treatment is you send your proceeds to a qualified intermediary, and you got 180 days to buy a replacement property. All right? So to Michael's point, a leasehold interest of 30 years or longer. And what I mean by 30 years or longer is there has to be 30 years left on the lease. You can't be in year 15 of a 30-year lease, but you could be in year 1 of a 35-year lease. As long as you got 30 years left, that leasehold interest will qualify as a fee interest in real property. So you could sell or buy a leasehold interest and exchange it for buying a piece of dirt. Okay? Nice thing about 1045 is all dirt is considered equal. So you can sell a conservation easement for soil purposes on your farm and use it to go maybe diversify and buy a commercial shopping center or a Walgreens pad or the newest craze Wawa and diversify what you're doing, create an income stream, and not pay tax on that. The second way that this can happen is under involuntary conversions under Section 1033. Very similar to a like-kind exchange, except an involuntary conversion is exactly what I just said. It's not voluntary. Comes up theft, seizure, and in this case, condemnation, or the threat of condemnation. So if the Water Management District comes over and says, I like your land, I have the ability to take your land, would you like to sell it to me for a mutually agreeable price, or a conservation easement for a mutually agreeable price, and we won't go through the court proceedings. And in that case, you can then use the money to buy replacement property, but unlike 1031, the like-kind exchange, if it's property used in a trade or business or held for investment, you've got 3 years to acquire the new property, and you don't have to specifically trace the funds. So if you're in a situation where a government agency is really looking at your property and it doesn't qualify for these other treatments, if you can fit under 1033, it's a lot easier for you than fitting under, it's a lot easier for you to implement because you got more time to think about it. With that, I'm done.
In your materials is an outline that summarizes these points that Brad's brought up. And the reason why we wanted to get into some of these other issues like 1031, 1033, is that we knew we were going to have some of the executive directors of the water management districts here. And with a little help, we could help you structure some things that have some tax incentives for the landowner that they might not have gotten otherwise. So we'd be glad to help in any way we can along those lines. We'll close this session. I do want to introduce a few of our other attorneys that have joined us today. We have Kerry Roth in the corner over here. We have Mark Levitt over here. Anna Long is here somewhere. Dennis Court, many of you met earlier. He had to leave. They'll be with us for this. They came here in time to go have cocktails with us, so they planned that out pretty well. I want to thank all of our panel members. Thank you so much for participating in this discussion. And unless there's another question, we will adjourn. Okay.
I adjourn. Thank you very much, sir.